why are you asking for something that we didn't even ask for? This is a sua sponte, on the court's own volition, interference in this case. The judge is supposed to be a neutral arbiter who doesn't just bring into action like a jack-in-the-box to come out and impose new conditions on people because he's upset that they got a pardon. No prosecutor asked them to do this. The defendants, of course, did not ask them to do this. So the judge just decided, quote, President Trump and the new DOJ are giving the old proverbial backhand to a DC judge. You can see his name is Judge Amit Privayadan Mehta, and he was the judge presiding over the Stewart Rhodes and the Oath Keepers case and prosecution. On January 24th, on his own, the judge Amit Mehta dropped this into the courts. U.S. District Judge out of the District of Columbia, saying here's an order now amending conditions of release. Now, these guys are pardoned and commuted, which means they don't have any continual penalties that are associated with this case. And we're going to see what the DOJ says about this, but the judge just did this on his own. Says this court hereby amends the condition of supervised release for these defendants: Stewart Rhodes, Kelly Meggs, Kenneth Harrelson, Jessica Watkins, Roberto Minuta, Edward Vallejo, David Morshell, and Joseph Hackett, to change their release conditions. Now, when you're being prosecuted, you get release conditions. Okay, you're charged with the crime. If it's a simple crime, you don't have a criminal record, you don't have any evidence that you're a flight risk or that you're a danger to the community or someone else, then they'll let you out generally on your own recognizance. You've heard this, OR release. Some people will be on pretrial services where they've got to do something. They got to check in, call a phone number. You know, is my number called? Is my color called? However it is in your state, check in and you're kind of managed. Then there's no release, right? You're held without bond. You cannot get out of custody for certain offenses if they're very serious and whatever. But once the case is over, a condition of their release, in this case, was they were not released. They were in prison. So they were commuted, and their release conditions are now moot because they are now pardoned and commuted. So here, the judge just on his own is going to impose new penalties and base them on, I can now control your conditions of release. So here's what he says. You individuals must not knowingly enter the District of Columbia without first obtaining permission from the court. So if Trump's going to invite you to some event, or you're going to come speak at some conference, or you're going to go to this thing or that thing, you cannot come back to DC unless you talk to me about it. You got to get a permission slip from me. And two, you must not knowingly enter the Capitol building or surrounding grounds known as the Capitol Square and consisting of the square block bounded by these locations: Constitutional Avenue, northwest to northeast, 1st Street, northeast to southeast. So between here and between here. Don't go in there. From this area and from this area, southwest over here, without first obtaining the permission from the court, this order shall be effective today at noon. So get out of DC or let me know that you're here. Now, guess what happened? President Trump's new DOJ doesn't like that. So they responded immediately. And you can see this one came out signed by Edward R. Martin Jr., who is now a United States attorney, respectfully submitted, says the following back to the court, responded immediately. Okay. Oh, Judge, just got your little order there. Thanks for that. Says this is the United States motion to dismiss the term of supervised release and probation pursuant to the executive order. So now, guess what? The United States of America, by and through its attorney, the U.S. attorney now for the District of Columbia, new sheriff in town, says the following. As this court is aware, Judge, an executive order was issued by the president on January 20th, granting pardons and commutation of sentences for certain offenses relating to the events on January 6th. Now, this proclamation included the above listed defendants in a list of the defendants whose sentences had been commuted. And we remember there was that list, and we broke it down. The first half was the Oath Keepers, the second half was the Proud Boys. And those were the seditious conspirators. Okay, nobody got charged with insurrection, but of all the J6 cases, those were the two that they bundled up and said there was this massive conspiracy because some guys wrote some things in a chat one time. The executive branch, they say, hey, so you're clear about this, according to United States versus Nixon, a U.S. Supreme Court case, says the executive branch has exclusive authority and absolute discretion to decide whether to prosecute a case or not. And so this court entered an order this morning amending the conditions of release. But the defendants, however, are no longer subject to the terms of your supervised release and their probation because as the order was signed by the president, it says in quotes, in case you need to read this again, Judge, it commuted the sentences of these defendants, which means they're commuted because it's in the order. Now, as the terms and supervised release conditions and the associated probation are included in the sentences of the defendants that you have control over, this court may not modify the terms of supervised release because the term supervised release is no longer active by effect of President President Trump's executive order, citing another U.S. Supreme Court case saying, hey, by the way, the Supreme Court has also acknowledged that an accused final sentence, when they're actually sentenced, it includes supervised release, right? That's still a penalty. You're still on supervised probation. You still have to contact your probation officer, unless it's unsupervised. But you still have a penalty, like you're on condition, you're on notice with the court. Somebody is monitoring you. You'll have a hall monitor that he may receive, and therefore supervised release punishments arise from and are treated as part of the penalty for the initial offense. So you cannot continue to exercise this against these oath keepers, saying the United States hereby indicates that the order must be vacated. So get rid of it. Respectfully submitted, Edward Martin Jr. Amazing. Okay, so not playing around, just saying you can come back here and throw your little hissy fit. And earlier this week, we talked about Beryl Howell and how she was saying democracy. And then Judge Chutkan was talking about feces all over the place. Didn't check Biden's office for any of that. But the point is, amazing response from the DOJ. And they're saying back to this judge, why are you asking for something that we didn't even ask for? All right, this is a sua sponte, on the court's own volition, interference in this case. The judge is supposed to be a neutral arbiter who doesn't just spring into action like a jack-in-the-box to come out and impose new conditions on people because he's upset that they got a pardon. It is an indication that they are as biased as we thought they were because they're doing this on their own. No prosecutor asked them to do this. The defendants, of course, did not ask them to do this. So the judge just decided, coat, we lost. So what can I do? What levers of power do I have to manipulate this so I can feel good about myself and go to bed? And it's a violation of their judicial oaths to be neutral and independent. So now the DOJ is stepping in and saying, you cannot do that. The president has issued his order, and now the DOJ will formally make it known, you must drop this immediately.